Okay. This is just a little video showing you the structure and the function of the court system. If you don't know anything about how the court system is structured, it can be very difficult for litigants to figure out what court they're going to, and I'm not even talking about just physically, although that's another barrier. Different courts do different things, and there's a reason that this matters. It's all about a chain of command because it's all about the concept of precedent. Nothing matters in the law more than precedent. Sorry, my dog's down here. I tell all of my students on day one, no one cares what you think. And that's not because you don't have valid opinions, and it's not because you can't do good things with the law. It's because no one cares what anyone thinks. No one cares what I think. No one cares what a judge thinks. No one cares what lawyers think. People care about two things. What can you prove? It's not about what you know, it's what you can prove. There are lots of different phrases in the law, some of which are better than others. Possession is 9/10 of the law is junk. It's not true. It's not what you know, it's what you can prove. That's exactly true. If it doesn't happen on paper, if it doesn't happen in a courtroom, if it doesn't happen in the presence of the court reporter, it didn't happen. So what can you prove? That makes it makes a difference to everything. The second thing that matters a lot when we're talking about what happens in a courtroom and what decisions are made is what has already been decided. This is the concept of precedent. And nothing matters more in a courtroom than precedent. Yeah, you've got facts. Yeah, they're great. But you can have the best facts in the world, but if the precedent is not on your side, you're not going to win. Nothing's going to happen for you. Precedent means that another court, and we're talking about a higher court, in the same jurisdiction, and when I say jurisdiction, I really mean the chain of command. I'm going to tell you what that is in a minute. Has ruled on our issue. So precedent, it's the concept that it's already been decided. A really good example of this is when the Supreme Court finally established that people have the constitutional right to marry someone of the same gender. When that happened, Obergefell was the case, and I'm sure some of you are very familiar with it. When that was decided, there was a judge in Alabama who said, well, not in Alabama, it's not. And so there was a judge who, for a very brief period of time, just decided that he was not going to follow that. Well, the Supreme Court decided that, and I'm going to show you a chart in a few minutes that shows you why the Supreme Court is so important. The Supreme Court had already decided that. When the Supreme Court speaks, especially on a matter like that, it matters for the whole country. So the judge in Alabama can't just say, well, not in Alabama, we don't believe in that, because of the concept of precedent. The Supreme Court is a higher court in the same chain of command, and they have already ruled on that exact issue. So that judge did that for about a hot minute before the appellate courts and the federal bench smacked his hand. And I don't think that man is a judge anymore, because you cannot do that. It doesn't matter what he thinks. It doesn't matter what he believes. It doesn't matter what his personal convictions are. If his personal convictions are against the law, then he needs to not be an officer of it. So the concept of precedent is as old as it's old. It's been around forever. And it's how we make decisions. And it's the concept of, it doesn't matter whether you agree with it. You have to understand it, and you have to follow it, but it does not matter what you think. What matters is what's been done before and what the law allows you to do. And so the concept of precedent, a higher court in the same jurisdiction has ruled, you must follow it. Your court must follow it. So let's take that one step further. Here we go. And I'm going to show you what I mean by jurisdiction, or what I mean by this chain of command, because not every court decision, not every court opinion is precedential. So, this is what the court system looks like. And at the top, I'm going to abbreviate. We have SCOTUS, the Supreme Court of the United States. Now, we have two main systems of law in the United States. We have state systems and we have federal systems. You're going to learn about this in civil procedure too. Any given person is under the purview of both of these jurisdictions at the time, and there's a lot of law on how they interplay with each other and how they interact. They're what we call separate sovereigns. They're both separate sections of the government, and but they're organized very similarly. And this matters because the Supreme Court is above both of them. The Supreme Court has authority over all of the other federal courts and over all of the other state courts. Now, they don't see every issue because there are some issues that just don't go to the Supreme Court. But no matter what, if I am all the way down here at trial court, put the trial level down here. In federal courts, we're going to call that district. And in state court, that's going to vary. It's a bunch of different things. It could be circuit. It could be district. If you're in New York, they've picked the absolutely most confusing thing possible to call it, and they're going to call it Supreme Court. I digress. Court of Common Pleas. County court. There's a bunch of different names that we can call the trial court, but let's just agree that this is a state trial court, whatever your state may call it. If we're in trial court in federal court, that's the district court. And so we are arguing in front of the trial court, and we lose. Where does that case go? It goes usually to an intermediate, and I'm going to abbreviate here, intermediate appellate court. Appellate means appeal. So these are our first courts of appeal. And so I'm going to take my home state of Indiana. If I lose in Clark County Circuit Court, I'm going to file my appeal to the Indiana Court of Appeals. If I am in trial court in Indiana, I'm going to try this to the 7th Circuit. I have practiced in so many jurisdictions, I can't remember if that is right or not, what number it is, but I'll give you a map. There's several states are going to be in a circuit, and it's literally from when a judge used to get on a horse and ride the circuit from different jurisdictions because there wasn't enough work in one particular place to give him enough cases. So it's going to go to our district court here is going to be appealed to a circuit court. Then in federal court, that's it. And so it goes right to the Supreme Court if we lose. I have another option. If I'm in state court, I can appeal my case from the Indiana Court of Appeals to the Indiana Supreme Court, and then from there, on certain things, to the United States Supreme Court. It depends. And we won't get into all of that jurisdiction right now. But if I'm just talking about precedent, and I am in a trial court in Floyd County, Indiana, I'm going to want to get cases that are precedential. Remember, it has to be higher, so it has to be this line or above. Now, if I'm in Floyd County, Floyd and Clark are the two main counties in Indiana right across the river. If I'm in Floyd County Circuit Court, do I give my judge a case from the Clark County Circuit Court? No. It's the same jurisdiction, meaning it's the same side of the page, but it's at the same level. And so that case is not going to make a difference. That's why we don't see a lot of publications coming out of trial courts, because they have no precedential value. I'm going to want Indiana Court of Appeals cases and Indiana Supreme Court cases. Same thing if I'm arguing something in district court. I'm going to want Seventh Circuit cases or whatever circuit I'm in, and United States Supreme Court cases, because they are above this line, meaning they are precedential. They are a higher court in the same circuit. Now, in Indiana, both Indiana Court of Appeals cases and Indiana Supreme Court cases are going to have precedential value over state court cases. And in district court, the federal system, Seventh Circuit and Supreme Court cases are going to be precedential. In some states, we don't have an intermediate appellate court. So some states out west are small enough jurisdictions that they only have one level of appeals, but most more populous states have two. Okay, so when you are researching, you are not going to see cases here because we don't keep as much track of them. They tend not to be published because they have no precedential value. I'm going to want cases from here and above, and that's why that matters. So when you do your first searches in Lexis and Westlaw, you're going to find this. You're not going to find trial courts because they're only so relevant to us. The other thing that I wanted to talk about is persuasive authority. So that's what we call binding authority, that precedent. If it's precedential, if it's in my chain of command, if it's in my jurisdiction and above me, I must follow it. Now, are there cases where the Indiana Court of Appeals, let's say, just hasn't decided a particular issue? You would think by 2021 that most things have been talked about. Well, but we have new stuff all the time. Like, when was the last time we had a mask mandate in a public school? That's not readily accessible in Indiana. But let's say I'm in Indiana and our jurisdiction we're going back to masks again, just has not talked about masks in public school at all. Am I done because there's no binding precedent? We might find some persuasive authority instead. Now, trial courts here, are they bound by circuit decisions? No. Why? It's over this line. You can't cross this line, and you must cross this line. Now, they're not binding authority, but many trial court judges look to the federal circuit courts to see what to do. So we would call that persuasive. If I'm in Indiana and I don't have a case on point, but I know that there's a Seventh Circuit, my circuit particularly, I'm going to look there first. There's a case in my circuit out of federal court from an Indiana, from the Northern District of Indiana. I'm going to use that to persuade my judge because trial court, state court judges are often persuaded by federal authority. There is a lot of weight given to federal authority because if there's ever a conflict between federal and state authority, federal wins. That's supremacy. So that might be persuasive. I'm only going to rely on it if I'm making an argument to a court if I have a good reason to. And a good reason is Indiana just hasn't decided this. So we gotta do something, Judge. The best thing for us to do is look at a Seventh Circuit case. And that might be helpful to us as well. So, being that the Supreme Court is the court of last resort for both every single state and DC, and the federal system, these Supreme Court cases become really important. There's not a Supreme Court case on every particular subject you're going to want to look at for some very specific legal reasons. But our basic research is done at this level and above because of that concept of precedent. I will also say that even when we have this persuasive authority, we are not going to see district opinions like we'll see Seventh Circuit opinions. They're going to be much more influential on a trial court than a sister county would be or a district court opinion would be. So those are going to be your persuasive authorities. This is what we're looking for when we research, and these are the cases that give us those precedential rules of law that we must follow and we use on our client's behalf to make arguments. And that's how the court system is organized. Every single one of these trial courts are the ones that have juries. They have bench trials. They are fact-finding courts. These are courts of appeal, and they only work on cases with a few very specific exceptions that have already been through fact-finding. So we find facts here and we apply law, but we only use the law really here. We don't do fact-finding. We don't bring everybody else in. We don't relitigate cases. We don't have witnesses testify again. And that is how the court system is organized.